Washington Journal continues.
And we're joined now with the Mercatus Center's Brent Skorup. He's here to discuss the Supreme Court's decision to hear a major cell phone privacy case. Brent, thank you so much for joining us today.
Kim, thanks for having me.
And so the Supreme Court decided to hear next term the case of Carpenter versus the United States. Tell us the story behind this case.
Sure. So the court, as you said, agreed to hear this next term, and the case involves, privacy and big data and police collection in the internet age. So in this case, according to the government, Timothy Carpenter was the mastermind behind a string of armed robberies in the Detroit area and northern Ohio. And police arrested one of the suspects, and the suspect turned over Carpenter's phone number, and with that information, they went to Carpenter's phone company and subpoenaed about 4 months of his phone records. And this is about 186 pages of his phone records. This included numbers he called, the duration of the calls, but critically it included some location information. And so when people use a cell phone, they connect typically to the nearest cell phone tower. So you can't pinpoint where someone is, but with that cell phone information, you can get it within a mile or half mile generally. And so they had a lot of data on Mr. Carpenter, and with this evidence, he was convicted of taking part in 6 armed robberies in Detroit and northern Ohio. And so he's alleged, he claims that his Fourth Amendment rights were violated. And so the Fourth Amendment protects our persons, our houses, our papers and effects from unreasonable search and seizure. And generally this means that police, when they search or seize these things, papers or effects, they need a search warrant, they need probable cause. And in this case, as is typical, police just use a subpoena to get this information on him, and he alleges that violates Fourth Amendment. And it's a big privacy case. There's a lot of interest in it. People are increasingly putting data online, and our smartphones have changed our relationship with third parties like this.
Absolutely, and Roll Call has a little more about the case. It says the case centers on the increasingly detailed information that companies keep on texts and calls to and from a cell phone, as well as the relatively precise location that can be gleaned from that information. The question is whether cell phone users can expect that data to remain private and subject to the Fourth Amendment's protection from unreasonable searches and seizures. Now talk a little bit about that expectation of privacy. We do live in an era where we know our cell phones track everywhere we go, and also people, they voluntarily give up a lot of information when they post online from their phone about their location. So is there an expectation of privacy in that information?
Yeah, that's right. So the courts, Supreme Court in the 60s and 70s announced this expectation of privacy standard, which courts use to determine if a search has occurred, if a search or seizure has occurred. And courts have held that if you don't have an expectation of privacy to information, it's not a search, and this is what the lower court said in the Carpenter case. He knows, or he should have known, that phone companies are collecting his phone information, including his location, and therefore it's not a search when police subpoena that information. I think it's a question if people know this. I mean, we turn over immense amounts of data, and people I talk to I think are surprised at how much information they're turning over, perhaps inadvertently, that people can receive. And so there's a hope by civil liberties groups on the right and left that the Supreme Court will take this case and kind of reevaluate, does this reasonable expectation test, which is from the 60s and 70s, does this make sense in the internet-connected world where we all are turning over immense amounts of data to third parties? Okay,
we are joined by Brent Skorup. He is the Technology Policy Program Research Fellow at George Mason University's Mercatus Center. Republicans can call 202-748-8001, Democrats 202-748-8000, and Independents 202-748-8002. Now, we talked a little bit about so much, all the information that cell phones gather, but remind our viewers just how much information. I mean, most of them have cell phones, but they may not even realize just how much information these phones contain about their everyday lives.
So I think most people with smartphones have dozens of apps, and we all kind of just click the agreements to have those apps. And so our phones are sending a lot of information to third parties all the time. And under this third-party doctrine, this reasonable expectation of privacy doctrine, we don't have an expectation. It's not a search if police seek this without a warrant, with a subpoena. So we're turning over an immense amount of data. You know, I mentioned just 4 months of Carpenter's phone information was 186 pages, which included numbers he called and his location. And it seems to encourage low-value fishing expeditions by police. And so Verizon said last year they received 120,000 subpoenas from police in these cases. So that's not search warrants, that's just subpoenas, about 300 a day. AT&T, similarly, they break out location requests from police, and that was 75,000 in a single year. So about 200 location requests from AT&T on their subscribers' locations every day. And with the Internet of Things, which is devices will all be connected.
Right.
People are putting Nest cameras in their homes, and if that's uploaded, that's in these courts that recognize the third-party doctrine that can be collected without a warrant. And so you see this collision of modern technology pushing up against this third-party doctrine, this idea that you don't have an expectation of privacy to any information you turn over to a third party.
And this sort of area of law was shaped, this opinion piece by the New York Times points out that this area of the law was shaped back in 1979, a court decision by the U.S. Supreme Court, but that dealt mostly with rotary phones and phone book listings. And it says there's good reason to question the scope of that doctrine now, when virtually everyone is online virtually all of the time, being exposed to constant, warrantless digital surveillance. In 2012, a Supreme Court ruling that the police needed a warrant to track a car with a GPS device. Justice Sonia Sotomayor said in a concurrence that the doctrine is, quote, ill-suited to the digital age in which people reveal a great deal of information about themselves and third parties to third parties in the course of carrying out mundane tasks. So making this case there that it's a big difference between allowing your name and address to be printed in a phone booth to now allowing someone to access information about your bank records, about what you eat, where you shop, and even more personal activities.
Yeah, that's right. And the case you referenced, the 1979 case, Maryland versus Smith, the court analogized. So they used a pen register to detect what phone numbers he was calling. And the court at that time said, people are used to calling, operators, decades ago, and this is akin to an operator. People didn't have expectation of privacy with an operator, therefore they don't have it with their phone company, even though that's an automated process. And I'll add that the third-party doctrine is not, it's not strictly in the Constitution. The Constitution talks about papers and effects. There isn't this third-party doctrine. This kind of overlays the Fourth Amendment, and it's, civil liberties groups are hoping that the Supreme Court will question this doctrine because it's not strictly constitutional.
All right, and we have one of our viewers on Twitter, Jody, points out, anything you do or say, they involve electronic devices, is there to be used against you in a court of law. Don't expect it anymore. Should people expect that when we live in a digital age and there's so much information available about people, that should lessen their expectation of privacy?
So I think it's time to reevaluate. I mean, like I said, I think most people would be surprised to learn that they've forfeited their Fourth Amendment rights essentially when they turn this over to a third party. I think that's a dubious premise, and as I said, it's kind of extra constitutional. It's developed by lower courts based on some language from the Supreme Court, and most people, I think they do expect that their privacy is protected by these companies, by these third parties. I mean, by law and by contract, these companies must protect the privacy of their subscribers, and there are big fines if they share sensitive information with commercial users, but that's not the case for law enforcement, and there's a disconnect there.
Okay, we are talking with Brent Skorup of the Mercatus Center about this big case coming up before the U.S. Supreme Court next term that will really help determine the limits of the Fourth Amendment limits of collecting cell phone data. Republicans can call 202-748-8000. Democrats 202-748, I'm sorry, Republicans 202-748-8001. Let's get this right. Democrats 202-748-8000, and independents and others can call 202-748-8002. Now, if the court agrees with the defendant in this case, Mr. Carpenter, how might that change just what are the implications for cell phone data policy?
So there are numerous ways that the Supreme Court could approach this issue. And the hope of civil liberties groups is that perhaps the third-party doctrine that's developed over several decades will be narrowed or perhaps not used anymore. And so that would give people more protection of their privacy, of their information when it is turned over to third parties. Because right now, as I said, there's a lot of fishing expeditions going on by police. A lot of innocent people's data is being collected. And so if the Supreme Court does put some more limits on this third-party doctrine, then people can expect more privacy. They won't have to be as concerned when they do turn over information and intimate information to the companies that connect us and bring us all these great internet services.
So should our viewers be concerned? Should they be doing something different with their phones for fear that this information may be more easily obtained?
So I think most people don't have any urgent, needs to be concerned about this. I think it's more of a long-term pernicious threat to privacy, and time will tell what the court does. But I think people's expectations have changed since the 60s and 70s. But most people don't need to be concerned. There are statutes out there that protect some of this information, particularly content. Congress has passed laws. Some state courts have protected against third-party use by law enforcement. And so, but the law is very confused, and some lower courts are asking the Supreme Court to take this up and provide consistency because it is a patchwork right now.
So Nathan Fried-Wessler, he's a staff attorney at the ACLU, who's one of the organizations representing Mr. Carpenter in this case, sort of explains the broader view about the impact of this case. He said, incidentally, the U.S. Supreme Court's decision comes on the 4-year anniversary of the first of Edward Snowden's disclosures, which revealed that the National Security Agency had been collecting sensitive records about virtually every phone call made in the United States. After an appeals court found that the NSA's bulk collection violated the law, and in response to the outcry over the revelation, Congress passed the USA Freedom Act to restrict the government's surveillance authority. Depending how it decides the Carpenter case, the Supreme Court could settle the broader question about how the Fourth Amendment protects all sorts of sensitive and voluminous digital records about communications and activities. I mean, this could be much broader. It can involve things like metadata and other things. How big could this case get?
Yeah, I mean, it's up to the court, and I mean, the Supreme Court generally doesn't like to make sweeping changes to court precedent. So, the smart money, I think, would be this would be a narrow decision about location data in particular, but there is a chance, especially with lower courts asking for guidance and asking for limits on this third-party doctrine, that the court could make a more sweeping decision. And I'll add, I mean, there's a lot of interest, particularly since Snowden, on the left and right about government collection of data. And so, for instance, the Wall Street Journal reported in October that federal agents in Southern California were using state license plate readers, which collect, record license plates, hundreds over an hour. They were driving around a parking lot at a gun show, and conservatives were, upset about this. And so this could have impacts on that sort of data collection. Progressives, have pointed out police in states have spent millions of dollars on what are called stingrays or cell site simulators, and what these do is they basically jam cell phone signals and force cell phones onto a police network, and with that they can collect information about who's in the vicinity. And progressives have alleged at protests that this is being used to identify protesters. So there's a lot of interest on right and left, and the Supreme Court could provide more protections against this sort of data collection. All
right, Michael is calling in from Slingerlands, New York. On our Democratic line, Michael, you're on with Brent Skorup.
Hi, how are you guys?
Doing great. Thank you, Michael.
Hey, it's just derivative off that thing going way back when they wanted Apple to unlock that phone so that terrorists down, I believe it was Texas, the guy that shot up a military base.
Right. So the Supreme Court, not in that case, but in a similar case in 2014, the Riley case held that phone devices are effects protected by the Fourth Amendment, and generally police do need a search warrant to access personal devices like that. The constitutional analysis changes when that information is transmitted, as it often is, to a third party if it's uploaded to Apple servers or Google servers, if you're using Dropbox or sending a text message. If it leaves your device, essentially, or your home, it receives reduced Fourth Amendment protections.
So talk about that a little more. So if it's the data that is on your phone is locked, a police officer cannot force you to unlock that, but if that phone is transmitting data, it's another standard.
Right, so this is the third-party doctrine treats your own devices as effects protected by the Fourth Amendment, and it doesn't treat transmitted data as effects that are protected by the Fourth Amendment. So yeah, this is that third-party doctrine that's evolved since the 60s and 70s that civil liberties groups and some federal courts are saying, in this age of internet connectivity, when we all have dozens of apps, they're sending information at all hours of the day. And increasingly, we're putting these devices in our homes. It makes sense to update this law and the third-party doctrine and protect people's expectations.
Okay, Gary is calling in from St. Helens, Oregon, on our Democratic line. Hi, Gary.
Hi. Good morning. Thanks for taking my call.
Morning, Gary.
I'm just kind of curious. I mean, we just had this thing that was passed about the internet provider, server, or whatever, being able to sell information. Does that overlap into this thing that you're talking about now? And I guess I had one more comment that, if you're not doing anything wrong, why should you be worried about, if the law gets a hold of information or whatever on you? If you're not doing anything wrong, then what's the problem? And that's what I had to say about that.
All right. Yeah. Thank you for the questions. And so I think you're referring to the FCC's Title II regulations recently, and Congress passed a law that so the Obama administration, late in the administration, passed some privacy regulations for internet service providers, and that's a separate issue. That's it's related in ways that they are third parties that if you turn information over, police can get it often with a subpoena. But in that case, that's commercial regulation of data. That's about what ISPs and websites can sell, and that's handled by the Federal Trade Commission, and they regulate this heavily. So sensitive data is heavily regulated. Commercial companies can't sell that without user consent if it's sensitive data. And the second question,
if you don't have anything to hide.
Yeah, if people don't have anything to hide. So yeah, I think that's a popular sentiment. I think the Fourth Amendment protects regardless, and it's meant to protect innocent people. And there's presumably, with all this data collection, there's a lot of innocent people's data being collected. People who have not done anything wrong. I'll add something. Reuters had a report a couple years ago that a DEA agency with all this collection going on of phone and internet content, there's government agencies that are coordinating and calling up like state lawmakers and saying, go to this truck stop and find a reason to stop this car and search in it. And so that's kind of pernicious collection of data that it violates the rights and norms I think people expect law enforcement to have. So it does capture innocent people, and there is some evidence, according to Reuters and others, that police are misusing this data in some cases.
Could the Carpenter case affect devices other than cell phones that we think about? I mean, we have devices in our homes, whether it's wireless connections or other, Alexa, all these devices that do transmit information about what we're doing, what we're watching. Could this apply to those too?
Yeah, it could. The court the narrow question before it is location data collected from a cell phone company, is that a search? The Supreme Court can open that up and reevaluate the third-party doctrine generally and all this information that we're sending out. Justice Sotomayor, as you mentioned, has shown an interest in reevaluating the third-party doctrine, and it's hard to read the tea leaves on this, but there may be an appetite by some on the Supreme Court to make this about a bigger issue than just location data from a cell phone company. So yeah, it could apply to all the internet connectivity and things that we upload all the time.
Okay. Catherine's calling in from El Monte, California. On our Republican line, you are on the line with Brent Skorup. Sorry.
Yes. I'd like to know, since we recently found out that millions of people have been listened in on and have their information taken by the FBI and all of these other people, and we find out that the FBI director is leaking things to the press, and they're crooked. And so now, what are they going to do about all of that? Here we're being listened in on. Things are being leaked to the press that are not true by the heads of our FBI, for goodness sake. What is the Congress going to do about that? What is your law going to do if you get it through the Supreme Court? What is that going to do for us out here?
Right. So the Supreme Court isn't taking this up strictly. I think you're representing a view that there's a lot of misuse of user data, and as I said, the phone companies are turning over. I mean, not voluntarily. I mean, police are subpoenaing them for hundreds of thousands of records. The Carpenter case, 4 months of records was almost 200 pages of phone data. So it's a tremendous amount of data. It invites misuse in many cases, and there's a lot of people are being caught in the crossfire of all this government collection of data. So in a digital age, and we have a Fourth Amendment that was written hundreds of years ago, is an amendment to the Fourth Amendment required, do you think, to sort of keep up with the legal issues that arise out of use of digital devices? So yeah, I mean that's I don't think so. In a word, I think the Fourth Amendment is flexible enough, and the justices have shown an interest in recent years of modifying the Fourth Amendment. So they did recognize a cell phone as one of these effects protected by the Fourth Amendment, and some courts are protecting cell phone data and these other records as papers that are protected by the Fourth Amendment. So I think. And there was the Jones case in 2012, I believe, where they recognized, so the police attached a GPS tracking device to a suspect's car, and the Supreme Court said, a car is one of these effects that are protected by the Fourth Amendment. So I think, this language is flexible enough, and courts draw analogs to what is from the 1700s and 1800s. So I think it is adaptable, and it could be updated. Okay, Peter is calling from New York State. He's on our independent line. Hi, Peter.
Hi. Hey, Brent. Could you tell me the difference between a court order and a subpoena?
Court order and a subpoena. Yeah, I don't know the exact requirements. I mean, generally under the Stored Communications Act, you can get a subpoena or court order if police believe it will be helpful, basically, in the case of an investigation. So it's a lesser standard than probable cause, which is basically there's more likely than not that there was a crime committed. A court order and a subpoena is less than probable cause, and it's easier for police to get. And that would require a warrant, right? Yeah. So probable cause is what you need to get a search warrant for devices or for information that's online. Okay, Brent Skorup, Technology Policy Program Research Fellow, that's a mouthful, at the George Mason University Mercatus Center. Thank you so much for joining us here today, and you can find out more at mercatus.org. Thanks so much. Kim, thank you. And coming up,